back to A Minute with Mitch, and I'm with Solutions for Real Estate. One of the questions I just recently had lately was about local laws here in Central Ohio, or specifically maybe Columbus. And I got a few notes here that I want to put down here. I had basically every state has tenant landlord laws, which you should make yourself familiar with it, even if we're managing the property or you have a property manager. And it covers probably about 95% of what the obligations are from each party, a tenant and a landlord. So, but here in Central Ohio, we have a couple things that we have to address with owners, and we try and remind them. One is registering your property with Franklin County or the county that your property is in. The owner has to do it. We cannot do it on your behalf. But it's done on the website. It's pretty simple. It takes 5-8 minutes. And basically, it's a result of the crash in 2008, 2009. The city could not get a hold of owners to clean up their property, a lot of out-of-state property owners. And if they find out that you do have a rental and it's not registered, you get fined for that. But there's no cost for this. They just wanted to know, who do we contact in case the grass is growing or someone's dumping, tires in the yard or whatever it might be. So that was a result of the market crash. The second one is the tenant's ability to put the rent in escrow. It's interesting that if you have less than 3 properties here in Central Ohio, they are not supposed to put their rent in escrow, even though it's recently happened to me. The courts don't, you still go through mediation before you sit in front of a judge to say, hey, release the money, take it out of escrow. But technically, if you notify the tenant, which we do in our lease, if the owner has less than 3 properties, they are not allowed to put their rent in escrow. So we do that right at the beginning, notifying them. So the last one is not necessarily a law, but it's the policy of City of Columbus Water Department. And this is just crazy. The City of Columbus has a AAA bond rating for their water, and what that means to a landlord is even though the water is in the tenant's name and they are responsible, they can rack up to 6-7 months of water bills and stick you with it. And it's amazing how many tenants know this. I think they talk to each other. But you're ultimately responsible for the water bill, and it's impossible to get it turned on for the next tenant unless you pay the bill. Unfair? Absolutely, it's unfair. Me being a fellow investor, I can't understand why they do that, other than they want to make sure that their bills get paid. But by having that ability to put it on the landlord, they can go out and get bond ratings and do improvements. We do have a good water sewer program here in Columbus. So that's it, and that's something you should probably know if you're going to invest in Columbus. So good luck, and thank you.